It is a police officer's responsibility to read and to make sure that the juvenile understands his or her constitutional rights before proceeding with an interrogation. That requirement comports with the special care that must be taken with respect to the child's constitutional rights. The parent is not present to assume the role and responsibility of the police, but rather to act as a buffer and to assist juveniles in understanding their rights, acting intelligently in waiving those rights, and otherwise remaining calm in the face of an interrogation.
So now the court gets around this business about the voluntariness of the confession. They don't have to attack the facts of it. They just say procedurally, this was not voluntary, okay? Not voluntary because of the way things were handled. Okay, you know, you can kind of see that. But remember what we said before? The family court judge says, notwithstanding this confession, I don't need this to convict her. I find in the record there's sufficient evidence beyond a reasonable doubt to convict her of this offense, notwithstanding the confession. How are you going to get around that? How do they do it, Johnny?
We are hesitant to assume that any human being, even an experienced, thoughtful, and able family court judge, as the judge below undoubtedly was and is, can partition evidence and compartmentalize his or her decision-making so neatly, particularly when the evidence in issue is of such magnitude, the means by which the evidence was procured was so disturbing, and the judge has already rendered a determination on the ultimate question.
So this is something to keep in mind when you have a case where you're doing a bench trial, and there's some enormously prejudicial piece of evidence that the judge hears and rejects, okay? And says, oh, no, I'm perfectly capable. Let's say it's a motion suppress or something very important in the case. And the judge says, no, I'm perfectly capable of making determination without this. It's out of my mind. I'm not going to consider it at all. This is good language for you to utilize when you're making your pitch either for another judge or you're appealing the fact the judge would not recuse after that. What's the rest of them say, Johnny?
We do not believe that a broad representation requirement that would require the presence of an attorney in every such case is warranted. As we have discussed throughout this opinion, the presence of a parent is a highly significant factor in the totality of the circumstances analysis contemplated by Prescia, and generally, that reassuring presence will assist the juvenile in the exercise of his or her rights. We decline to embrace a categorical rule that an attorney must be present any time that there is perceived clash in the interests of a parent based on a familial relationship with the victim or another involved in the matter.
All right. So, bottom line holding on this case is they get rid of this concept of having an attorney come in, and maybe a parent can do it or maybe a substitute parent can do it in those instances where there is a true conflict. Again, I'm not sure this is all filtered down to the police because I would imagine these family conflicts happen all the time when there's interfamilial criminal conduct committed by juvenile suspects, and where the parent or guardian will have I don't want to say mixed emotions, but certainly mixed loyalties. So kind of keep that in the back of your mind. What's the rest of that say, Johnny?
Even in cases of such apparent clashing interests, a parent may be able to fulfill the role envisioned in Prescia. And in those cases where a parent is truly conflicted, another adult, not necessarily an attorney, may be able to fulfill the parental assistance role envisioned by Prescia. Moreover, when it is apparent to interrogating officers that a parent has competing and clashing interests in the subject of the interrogation, the police minimally should take steps to ensure that the parent is not allowed to assume the role of interrogator, and further should strongly consider ceasing the interview when another adult who is without a conflict of interest can be made available to the child.
So for those of you who are confronted with one of these juvenile cases, you've really got to scrutinize whatever the record is on it. Lots of times they'll be videotaped interviewed, especially if it's a criminal offense under investigation, and make sure that they've complied with the rules set down here, especially likely to happen when you're dealing with interfamilial problems. Everybody sensitized to that? Okay. What's next on there, Dino? Florida versus Powell. Let's see. What's this? This is really kind of a simple case dealing with Miranda warnings. Okay. In this case, the Florida police read a warning to the defendant, advising about his right to counsel, basically saying to him that in the beginning, you have the right to an attorney to represent you, and you can invoke any of your rights anytime you want. All right. Well, that didn't specifically tell the attorney that he could stop during questioning and ask for an attorney during questioning, okay? It didn't really make that particularly clear. So the issue in the case became whether or not that kind of at least from the defendant's perspective, confusing warning of his rights was sufficient constitutionally. Now, there's a very interesting procedural aspect to this case, which you kind of have to understand to see how the whole thing worked out. This is a case that went to the Florida Supreme Court. And the Florida Supreme Court found that the Miranda warnings given to this defendant were insufficient to explain to him what his constitutional rights were under Miranda, okay? And it's interesting because the Florida Supreme Court, in the opinion, they never said whether or not they were deciding the case under the Florida Constitution or under the United States Constitution. They didn't discuss that issue at all. If the Florida Supreme Court had said, we are deciding this under the Florida Constitution, then the United States Supreme Court wouldn't have had any jurisdiction to hear the case because it would have been decided under an independent prong of Florida constitutional law. The United States Supreme Court doesn't have any right to interpret the Florida Constitution. But they didn't do that. They didn't mention one way or the other whether it was being decided under United States law or under Florida law. This gives the court the opening that it needed to get involved with the case and say, number one, we have never ever come up with a specific language that has to be utilized when people are being Mirandized. We just haven't done it. We've told you about what you need to do, but we've never prescribed the specific words that have to be utilized. And we also find that the language used in this particular case was perfectly suitable from a federal constitutional standpoint to advise the defendant, okay? The Florida Supreme Court is just basically wrong in their interpretation of what the warnings should be. And it's obvious to us that lacking any explanation that they were deciding this under Florida law, we have to set the Florida Supreme Court straight in terms of what the applicable federal law is. Johnny, can you read that?
Miranda requires that a suspect be warned prior to any questioning that he has the right to the presence of an attorney. This Miranda warning addresses the court's particular concern that the circumstances surrounding in-custody interrogation can operate very quickly to overbear the will of one merely made aware of his privilege to remain silent by his interrogators. Responsive to that concern, the court stated as an absolute prerequisite to interrogation that an individual held for questioning must be clearly informed that he has the right to consult with a lawyer and to have the lawyer with him during interrogation. While the warnings prescribed by Miranda are invariable, this court has not dictated the words in which the essential information must be conveyed. In determining whether police warnings were satisfactory, reviewing courts are not required to examine them as if construing a will or defining the terms of an easement. The inquiry is simply whether the warnings reasonably convey to a suspect his rights as required by Miranda.
Very, very powerful language and helpful to prosecutors.
By informing Powell that he had the right to talk to a lawyer before answering any of their questions, the Tampa officers communicated that he could consult with a lawyer before answering any particular question. And the statement that Powell had the right to use any of his rights at any time he wanted during the interview confirmed that he could exercise his right to an attorney while the interrogation was underway.